land surveyor. And I will say that I do agree with Senator Evans that this is a problem. There have been times when my firm, when we'll have a 1% of the contract, we're required to take on 100% of the liability, which is really quite heavy-handed. However, I do believe this bill goes too far. I think there is a spot in the middle, I think, that would be fair for all parties. It's not fair to limit all of my liability. I think that I should, if I've made a mistake, I should be required to defend the contractor. However, this takes, I believe this goes too far and doesn't put any liability on the subcontractor. So I would offer my professional services in my experience in this area to Senator Evans to try to improve the bill, because I think you are on the right track, and I do believe this is a problem that has to be addressed. However, as I said, this bill goes too far, and I won't be able to support it, unfortunately, today. So thank you.
Senator Blakesley.
Thank you, Mr. President. Members, I supported the earlier bill that sought to address this very challenging question of who is liable between subcontractors and the general contractor / owner. And the reason I supported it was because significant compromise was taken so that all parties at the end of the day could support the final product. Having sat in committee and seen the testimony by those who are affected by this bill, I do not believe that compromise has yet occurred, and I am concerned to hear that the author, rather than seeking compromise, is instead exempting public employers, thereby only increasing the narrow focus that would hurt our private sector and private employers. Lifeboating or exempting public employers from the provisions of a bill is hardly the compromise that brings all parties together, and I'll therefore be voting no, but hoping to vote yes when this bill returns, if it gets off the floor today, as we do need to resolve this complex issue between the parties.
Further debate and discussion, Senator Weiland.
Mr. President, members, like Senator Cannella, this is not an easy vote for me to not vote for this, because I spent 20 years as a building material supplier, as a subcontractor. And I do believe and know that subcontractors are often taken advantage of by contractors. And the origin of these indemnity agreements, as the author has stated, was to, in many ways, have liability spread out and initial defense paid for by subcontractors who had no liability. That's absolutely correct. And this cries out for change. My concern is that we aren't using the change that Senator Calderon worked on. I believe also former Assemblyman Dave Jones worked on the residential side, and I actually believe that the pro tem worked on that issue, and we resolved it pretty well so that it was fair. I would love to have a bill right now to vote on, and I thought a long time about it. But my concern is that those amendments and other amendments could have been taken now. And the amendments are not those for public entities, but for private contractors who've been singled out, and for building owners who really have no liability. As Senator Cannella pointed out, this is, or perhaps Senator Walters, I don't recall which, but this bill will generate more and more and more litigation. Because what will happen is, as soon as there is litigation with defendants named as building owners or contractors, they will inevitably have to file suit against those subs because they can't bear it alone. I think there is a solution. I don't think this is it. Now, let me say one thing about the public entities and their opposition. I will tell you from personal experience, and this relates to other issues we have, there is not a bid for anything that goes to a public entity, state, federal, or whatever, that isn't more than you would pay in the free market. And the reason is the regulatory regime It can be Defense Department. It can be a state, a county. Is so onerous that you have to bid more. That's part of our regulatory environment. So to exempt them out, what you're dealing with, frankly, are bureaucrats who don't care and who are not knowledgeable. That doesn't solve the problem. The problem's real, and it just seems to me we ought to be able to solve it now, right now. And I personally would support any waiver, any action it took to do that, rather than wait for a proposed solution on the other side. So regretfully, I can't vote for that bill today.
Further debate or discussion? Senator Gaines, to be followed by Senator Calderon.
Yes, thank you very much. I think Senator Evans is on the right track in terms of coming up with a solution here, but I have some concerns. I want to make sure that subcontractors still have their obligation. It seems to me that all parties involved in construction have certain obligations. We need to make sure that those obligations are met. So in the event that you have a subcontractor who is in fact liable, we've got to make sure that that liability is not transferred to the general contractor. It seems to me that not all parties were at the table when these negotiations took place. We were talking earlier about the residential side of construction. That was a process where you had all parties at the table, and they arrived at a compromise that, quite frankly, has been very effective. And so that's what I'm looking for. And while I've seen Senator Evans taking the right steps forward, I feel that not all the parties have been included in this process and therefore cannot support the legislation. Thank you.
Further debate or discussion? Senator Calderon.
Thank you, Mr. President and members. I rise to offer my conditional support for SB 474. If this measure were in its final form today, I would not be able to support it today. However, as you have heard, having authored and been involved in a construction defect bill on the residential side, I know they are complex measures with many stakeholders. The process when we did construction defect for residential homes had many, many meetings, many layers, and requires a lot more time with stakeholders. I'm willing to offer Senator Evans and the bill's sponsor my support with this proviso. I will withhold my support on concurrence unless I'm satisfied that the issue raised by the opposition have been addressed in a fair and equitable manner, that the sponsor has promised me the amendments will be taken in the Assembly to ensure the body's ability to review the bill a final time, and also I will monitor the measure's progress in the Assembly and expect to see significant amendments to the bill before its first policy committee hearing. And having said that and understanding that, I will provide my support for this bill today to continue moving on and provide time to work on it further. Thank you.
Further debate or discussion? Senator Vargas.
Quick question to the author, if I may.
Question of the author. Are you prepared to accept the question? Please proceed.
Thank you very much. My understanding then is that you are going to take amendments in the Assembly and that in fact the bill will come back here and we will have an opportunity to look at the bill again, so it won't simply go down to the governor. If you pass it out of the Assembly, it will come back here. Is that correct?
Right.
With those assurances, I'm prepared to vote for the bill today, too. Thank you.
Further debate or discussion? Senator Correa.
Thank you. My question is very similar to the author, that want to make sure you have your commitment that that bill will come back for concurrence here. And let me say that that is an affirmative.
That is an affirmative commitment.
Thank you. And again, I just want to thank the author for bringing up an important issue, yet I think there's merits on both sides of the argument. You've addressed, and you are addressing a very important issue, but I believe you need to just work a little bit more to make sure that this is an issue that's solved to the satisfaction of all interested parties.
Further debate or discussion? Further debate or discussion? Senator Steinberg.
Thank you very much, Mr. President. I just wanted to add a little historical context to this, because back in the old days, when I served as a member of the Assembly, I took the lead in, with others, in trying to construct construction defect reform. And this issue of the relationship between the builders and the subcontractors, or the contractor and the subcontractors, was at the heart of that reform. And we were able to work it out. And now Senator Evans has appropriately brought forward a measure which seeks to essentially take the model that we were able to develop in the residential construction side and apply it to commercial construction. And it's true that the bill is not yet cooked, as they say. But I know from my own experience that without the creative tension that Senator Evans is creating in a very constructive way by pushing this bill forward, it will be difficult to get all the parties to the table to resolve this. And it needs to be resolved. And that's why it's important we move this bill out of the House. The first year of the 2-year session, move it out of the House, move it to the Assembly, let these negotiations continue, and let's get to a place where the law reflects what is the overall framework of the law in California. That is comparative responsibility and comparative fault. You defend what is yours to defend. You pay for your share of the fault and responsibility. That doesn't exist now. Under the law in the commercial side, a subcontractor can be 1% liable and pay 100% of the judgment based upon contractual indemnity. That's not fair and right. There needs to be a balance. This bill is the vehicle to get it done. Please pass this to the Assembly.
Further debate or discussion? Senator Harman. Senator Harman at Senator Harman's desk. Once again, please, Senator Harman.
Question of the author.
Senator Evans, you prepared to take a question? Senator Harman, please proceed.
Senator Evans, you've indicated that you're willing to take some type of amendments when the bill goes to the Assembly if it passes off the floor today. Can you give us some indication of what type of amendments you are tentatively agreeing to? I don't have any idea what the issue is, and wonder if you could outline us and why it can't be done here.
Well, actually, Senator Harman, that's a very excellent question, and I'm glad you gave me the opportunity to address that issue. I have attempted on many occasions, as have others of my colleagues on the floor who have been assisting me in the bill, we have attempted on several occasions to get proposed amendments from the general contractors and others who have an interest in the bill. The only amendments that have been proffered were those by the public entities, and I took the ones that exempted them from the bills. The other amendments simply have not been forthcoming. And so part of what I committed to most recently with the general contractors in my discussions late last night was to try to obtain some kinds of amendments about where they want to see this bill going. Unfortunately, because of the demands of time in the Senate, we don't have the opportunity to do that right now. It's been very difficult to get folks to the table to discuss this issue. There has been a recalcitrance in doing that. So my thinking and my commitment to everybody here today is to, once we've got this moving, and we do have it moving, having gotten everybody's attention, there should be an opportunity now to be able to sit down and try to work through these issues. But I have not had amendments to even consider at this point.
All right, thank you very much.
Further debate or discussion? Seeing and hearing none, Senator Evans, you may close.
Thank you very much. Members, I just want to address a couple of issues that were raised during the debate. For those that are claiming that that subcontractors would be completely without fault, that is simply not true. Senator Steinberg said it most accurately when he said it's comparative fault. That is the policy of the state of California and other areas. It's comparative fault. You bear the fault. You bear the responsibility to the extent that you are at fault for an injury or a defect. To those that claim that endless litigation will ensue, let me tell you, I've been a lawyer for more than 30 years now. I have handled many, many lawsuits arising out of construction contracts. The litigation right now is endless already. The owner sues the general contractor. The general contractor sues all of the subs, whether they have any responsibility or not. And I have had cases where landscape contractors have been brought into cases where the roof is leaking. Then all of the subs cross-sue each other, and they all tender the defense of themselves and the general contractor to their insurance carriers. Then the insurance carriers all sue each other. So there are at least 4 and sometimes 5 layers of litigation arising out of every single construction defect lawsuit. The litigation is endless, and I hate to say this about my attorney colleagues, but the only people who win are the attorneys. The burden on the courts is huge. It is costing all of us a lot of money here in the state of California, and that's the situation that this bill attempts to address. I've made my commitment. I hope it's very clear. I ask for an aye vote.
Secretary, call the roll.
Alquist, aye. Anderson, no. Berryhill, no. Blakesley, no. Calderon, aye. Canella, Corbett, aye. Correa, De Leon, aye. DeSaulnier, Dutton, no. Emerson, Evans, aye. Fuller, no. Gaines, no. Hancock, aye. Harmon, Hernandez, Huff, no. Kehoe, aye. LaMalfa, no. Leno, aye. Ted Lieu, aye. Carol Lieu, aye. Lowenthal, aye. Negrete McLeod, aye. Padilla, aye. Pavley, Price, aye. Rubio, aye. Runner, no. Semidian, Steinberg, aye. Strickland, no. Vargas, aye. Walters, no. Wolk, Wright, Weiland, Yee, aye. Hernandez, aye.
Call the absent members.
Canella, Correa, aye. DeSaulnier, Emerson, Harmon, no. Pavley, aye. Semidian, Wolk, Wright, Weiland, no.
Aye.
DeSaulnier, aye.
Ayes 22, noes 13. The bill is passed. File item 33. Senator Wolk. Mr. Secretary, please read.
Senate Bill 594 by Senator Wolk, enacting to public health.
Thank you, Mr. President and members. 594 will strengthen the local public health practices at labs by ensuring that the public health microbiologists are updated about advances in scientific knowledge. The infrastructure for these programs is already in place, and these measures should improve the local response to new disease threats. We have accepted amendments that meet certain of the county's objections. We continue to work, however, with CSAC as we move, I hope, to the Assembly, and I ask for your aye vote.
Debate or discussion? Seeing and hearing none, Secretary, call the roll.
Alquist, aye. Anderson, Berryhill, no. Blakesley, Calderon, aye. Canella, no. Corbett, aye. Correa, De Leon, aye. DeSaulnier, aye. Dutton, no. Emerson, Evans, aye. Fuller, Gaines, no. Hancock, aye. Harmon, no. Hernandez, aye. Huff, no. Kehoe, aye. LaMalfa, no. Leno, aye. Ted Lieu, aye. Carol Lieu, aye. Lowenthal, aye. Negrete McLeod, Padilla, aye. Pavley, aye. Price, aye. Rubio, Runner, Semidian, aye. Steinberg, aye. Strickland, no. Vargas, aye. Walters, no. Wolk, aye. Wright, aye. Weiland, Yee, aye. Runner, no. Anderson, no.
One moment, members. Secretary, call the absent members.
Blakesley, No. Correa? Emerson? Fuller? No. Negrete McLeod? Rubio? Aye. Wyland? Wyland, no.
Ayes 23, noes 14. The bill is passed. File item 34, Senator Pavley. Secretary, please read.
Senate Bill 152 by Senator Pavley, enacting to public lands.
Yes, thank you very much. Members, this bill will ensure that the state has a fair and uniform policy when it comes to charging rent for private recreational piers or docks that are built on state lands. The state already charges rent for almost all private uses of state land, including our state tide and submerged lands. This is existing policy. However, back in the 1950s or 60s, a rather obscure statute prohibited rent from being charged for just some private recreational piers constructed on state lands. As a result, we have some inequitable and arbitrary situations, such as piers in Clear Lake, Senator Evans' district, must pay rent for the use of state land, but some pier owners in Tahoe receive rent-free leases of public land. Another example, a family that owns a home as a family trust organized as an LLC pays rent for the use of state land, while their neighbor who owns a home as an individual pays no rent. HOAs pay rent for a pier or dock. Multifamily dwellings pay rent, but some single-family homes don't. Same structures, same use of public land, but different rent policies. Several years ago, an Attorney General opinion found that this rent-free provision is an unconstitutional gift of public property. SB 152 would simply require the State Lands Commission to treat all private recreational pier owners equitably. This bill will not change rent on any existing piers or docks until their leases expire, and all lease conditions and then would be negotiated and reevaluated. This is not a property right. It's not attached to the property. It's simply a fairness issue, and I respectfully ask for your aye vote.
Debate or discussion? Senator Harman.
Thank you very much, Mr. President. Members, in my hometown in Huntington Beach, we have a very large waterfront development called Huntington Harbor, which has hundreds of boat docks and slips that are built on the water. Huntington Harbor was built about 35, nearly 40 years ago, and dredged out of basically a swamp-type situation. And when it happened, the state said to the property owners that had joined the new waterways that were built, it's okay for you to have a wharf, a dock in front of your home. These are many cases now, they weren't then, but they now are $1 million homes. And they had the use of those docks for the past 35, 40 years with permission and consent and knowledge of the State Lands Commission. The State Lands Commission never asked them to pay rent. It was considered to be part of their home. When they sold their home, the dock went with it. And to now suddenly tell homeowners that have had access to their docks for all these years and decades seems inherently unfair to me. And the problem I have with the bill in a further regard is the State Lands Commission says that they're going to set the amount of the rent or lease payment on these docks, but there's no real solid criteria of what process will be used by the State Lands Commission to determine the fair rental value. There's some reference, I think, in the bill to what nearby rents are. Well, in the case of Huntington Harbor, there's not a lot of nearby rents. Surprisingly, some residents own their docks, even though they're on the same Pacific Coast Ocean water, They own their dock. They don't have to pay any rent. They own fee title to the center of the main channel or the side channel. But a few of the owners that are going to get caught up in this scenario are going to wind up having to pay rent on their docks and wharfs, and they don't know how much it's going to be. And the criteria are extremely vague and probably unenforceable when it comes to determining how much they're going to have to pay. So put yourself in their shoes. If you had a home with a dock in front of your home and you didn't know how much the rent was going to be on it for the next 10 years or 20 years, that's unfair. There should be some quantifiable method to set what the rent is going to be on these wharfs. I encourage you to vote no on this bill.
Further debate or discussion? Senator Gaines.
Yes, I want to thank Senator Pavley for taking the time to meet with me and discuss some of the issues I have. I'm still in opposition to the legislation, but she did provide some clarity for me. I go back to 1977 when there was a declaration made that piers were of benefit to certain waterways in the state of California, and I still believe that to be the case at Lake Tahoe. Within my district, there are a number of piers around the shoreline that are privately owned. Those can be helpful for individuals navigating the water, whether they are actually swimming and may get in distress and need a place to get to quickly, or if they're in a canoe or a sailboat or anything that may become stranded. And so I see a benefit to the public as a result of private piers around the lake. And from my vantage point, I can't see how you can then go back and charge folks for what I perceive to be a public benefit, and therefore am in opposition of the legislation. Thank you.
Further debate or discussion? Senator Wright to be followed by Senator Evans.
Thank you, Mr. President, members. When we heard this bill in GO, like a number of people, I had concerns that we might have been taking away a property right that someone acquired when they purchased their land on a lake. In fact, it's not a property right that you acquire. In fact, I called the State Lands Commission and spoke to the staff and some of the commissioners at length. What you acquire when you get a 10-year lease is just that. It's a 10-year lease. Current law does forbid the commission, in a law that was passed some 25 or 30 years ago, from charging rent. One of the problems that this creates, members, is that if you're unable to collect rent on that property, at some point as that dock becomes old, who assumes the responsibility for cleaning it up or doing the other maintenance work that might be done? Once we've verified that, in fact, it's not a property right that you acquire, but it's an individual lease that's granted to a person for a specified period of time. By the way, this free rent does not accrue to someone, for example, if it's a nonprofit organization. Well, excuse me, it does accrue if it's a nonprofit organization, but if it's a multifamily building, then they're not entitled to this same provision of discount. The other thing that we were concerned about was that the commission initially wanted to try to circumvent leases and be able to charge the additional rent within the lease period. One of the considerations that we placed in the bill was to say that the lease term of 10 years was a set term and that the change would only occur after that period of time that the lease was there. The other element that we were concerned, and I had the same concern that Senator Harman had, was that the commission has an obligation to charge a fair market rent. And there's a methodology that they use to do that, because that's what they do, whether it's at Clear Lake or Tahoe or the other places. The rent is charged on a fair market basis. I think that Senator Pavley took a difficult challenge of how do you take people who in some instances have been getting something for free for a number of years and come up with an equitable way to charge rent so that the lakes or the waterways or the rivers here in Sacramento are maintained in a way that's fair to all the people who might use them. I would ask for an aye vote on SB 152.
Senator Evans.
Thank you, Mr. President. Senator Wright did such a thorough job of outlining the issues. I won't go through them again and repeat them. I do rise in support of the bill. It is a fairness issue, and I'll just give you one example from my district in Lake County. My constituents who are pier owners in Clear Lake pay rent, while owners of most other areas of the state, including some pier owners in Lake Tahoe, are receiving rent-free leases. And this bill would change that inequity and make it fair around the state. I ask for an aye vote.
Further debate or discussion? Seeing and hearing none, Senator Pavley, you may close.
Yes, thank you very much, and I appreciate the discussion. Senator Gaines and Senator Harman. I also met with Senator Walters and Assemblymember Silva. Thank you very much, Senator Wright, for your comments. I think you outlined very well some of the concerns, and I appreciate the time and attention Senator Wright spent on this issue, including speaking directly with the State Lands Commission. I want to just clear up a few comments, at least from my perspective. Homes that have these docks or piers that have been getting a free ride for decades, there's nothing in the deed that made it that they have their pier or dock in perpetuity. It's always been a 10-year rental kind of period. And as far as fairness in negotiating what is a reasonable price to pay, it's based on what the surrounding rental piers and values are for your particular area. If you lived in the Delta or Clear Lake, it's going to be a lot less perhaps than if you're in multi-million-dollar homes somewhere else. But it's based on a negotiated process with the State Lands Commission, spelled out. They've been doing this for years because of the 10-year lease agreements that other people have been paying, or most of the state has been paying, based on criteria. The lease is negotiated, and if there are concerns by the property owner that that was unfair, then at a full hearing that the State Lands Commission have, that item would be discussed in depth and subject to a vote. One way you can compare is perhaps you have in your neighborhood a family that has a trust on a pier. Well, they're paying rent because they have not gotten the rent-free provision here. This is simply a bill to clean up inequity and have a fairness way of negotiating a fair price for the ability to have a pier or dock across state-owned lands. I respectfully ask for your aye vote.
Secretary, call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Aye. Cannella. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harman. No. Hernandez. Aye. Huff. No. Kehoe. Aye. LaMalfa. No. Leno. Aye. Tedlu. Aye. Carolou. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Smidian. Aye. Steinberg. Strickland. No. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. No. Yee. Yee. Aye. Cannella. No.
Call the absent members.
Correa. No. Emerson. Steinberg.
Ayes 23, noes 15. The bill is passed. File item 35, Senator Kehoe, pass. File item 36, Senator Corbett. Senator Corbett passes temporarily. File item 37, Senator Pavley. Mr. Secretary, please read.
Senate Bill 586 by Senator Pavley, enacting to banks and credit unions.
Yes, members. This particular bill was heard in Banking and Finance Committee and had a thorough hearing. It's co-sponsored by AARP and the California Senior Legislature, and it's aimed at preventing the physical and financial abuse of elder and dependent adults. And as you know, it's a growing problem in California. In fact, much to my chagrin, California's senior population will grow by 43%. That's over 6 million senior citizens by 2020. This bill, though, just narrowly goes after one particular issue, offering very basic protections for the issuance of signature stamps that are used for banking primarily by elderly and disabled adults. Additionally, the bill bolsters prevention activities by allowing a judge to double the existing fines, if warranted, for elder and dependent abuse crimes, and then allocating the increases of fines to adult protective services so that we can protect our most vulnerable citizens. I respectfully ask for your aye vote.
Debate or discussion, members? Debate or discussion? Seeing and hearing none, Secretary, call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Canella. No. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Huff. No. Kehoe. Aye. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Runner. No. Semidian.
Aye.
Aye. Steinberg. Strickland. No. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. No. Yee. Yee. Aye. Rubio. Aye. Calderon. Aye. Correa. Aye.
Call the absent members.
Emerson. Hernandez. Aye. Steinberg.
Ayes 24, noes 14. The bill is passed. File item 38, members. File item 38. Senator Ted Lieu. Mr. Secretary, please read.
Senate Bill 888 by Senator Lieu, enacting to crime.
Thank you, Mr. President, members. This is a bill that preserves the sanctity and dignity of funerals. And since time immemorial, humankind has acknowledged the sanctity and dignity of those ceremonies. And what we have seen is in some cases we've had hateful protests at funerals. And this bill is a response to the recent U.S. Supreme Court decision, Phelps versus Snyder. While I disagree with that decision, I do acknowledge the court has the power to render stupid decisions. This simply complies with that, and it says, if you're going to protest at a funeral, you must be at least 1,000 feet away, you must be on public property, and you cannot disrupt actual services. Over 40 other states and the federal government have placed reasonable restrictions on protesting at funerals. This attempts to put us into that same league, and the bill is supported by the American Legion, AMVETS, Vietnam Vets of America, Association for LAW Sheriffs, and other members of law enforcement, including Riverside Sheriffs Association. Respectfully request an aye vote.
Debate or discussion? Debate or discussion? Seeing and hearing none, Secretary, call the roll.
Alquist. Aye. Anderson. Aye. Berryhill. Aye. Blakesley. Aye. Calderon. Aye. Canella. Aye. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Aye. Dutton. Aye. Emerson. Evans. Fuller. Aye. Gaines. Aye. Hancock. No. Harmon. Aye. Hernandez. Aye. Huff. Aye. Kehoe. Aye. LaMalfa. Aye. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. Aye. Semidian. Aye. Steinberg. Strickland. Aye. Vargas. Aye. Walters. I, Wolk. I, Wright. I, Wyland. I, Yee. Yee, aye. Correa, aye.
Ayes 36, noes 1. The bill is passed. Members, during our first hour, we have managed to take action on 5 bills. 5 bills. While the debate has no doubt enlightened the decision-making of the body, I would simply suggest that if we could begin to move the pace along, that might ultimately be in the best interest of the House and of the product. So, file item 39, Senator Leno. Secretary, please read.
Senate Bill 32 by Senator Leno, an act relating to alcoholic beverages and declaring the urgency thereof to take effect immediately.
Colleagues, this bill passed off our floor a month or so ago on the consent calendar. We brought it back with bipartisan support, so I was able to add an urgency clause, which is before us today. And what this bill does is amend the state statute to allow for on-sale licensees of alcohol to be able to infuse or flavor drinks with fruits, vegetables, and spices for on-site consumption. Once again, I would ask for your aye vote.
Debate or discussion? Debate or discussion? Seeing and hearing none, Secretary, call the roll.
Alquist. Aye. Anderson. Aye. Berryhill. Aye. Blakesley. Aye. Calderon. Aye. Cannella. Aye. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. Aye. Emerson. Evans. Fuller. Aye. Evans, aye. Gaines. Aye. Hancock. Aye. Harmon. Aye. Hernandez. Aye. Huff. Aye. Kehoe. Aye. LaMalfa. Aye. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. Aye. Semidian. Aye. Steinberg. Strickland. Aye. Vargas. Aye. Walters. Aye. Wolk. Aye. Wright. Aye. Wyland. Aye. Yee. Yee, aye.
Ayes 38, no 0. The bill is passed. File item 40, Senator Kehoe. Forgive me, members. Ayes 38, no 0 on the urgency. Ayes 38, no 0 on the bill. The bill is passed. File item 40, Senator Kehoe. Secretary, please read.
Senate Bill 557 by Senator Kehoe, an act relating to family justice centers.
Thank you, Mr. President. Members, family justice centers are multi-agency locations that assist victims of domestic violence and their families. This bill authorizes 2 cities and 2 counties to participate in a study of family justice centers under the auspices of the Office of Privacy Protection. The study will determine best practices to ensure the protection of a victim's privacy, evaluate centers for their effectiveness, determine how the model can provide services in the most efficient manner possible, and cost-effective manner as well. 15 family justice centers operate in the state currently. Another 15 are coming online. It's time we set some guidance and statute for family justice center models. Members, the bill left Public Safety Committee, Judiciary Committee, and Appropriations with strong bipartisan support. I ask for your aye vote.
Further debate or discussion? Members, is there any objection to substituting the unanimous roll call on this bill? Seeing and hearing none, ayes 38, noes 0. The bill is passed. File item 41, Senator Semidian, passed temporarily. File item 42, Senator Semidian, passed temporarily. File item 43, Senator Carol Lieu. Mr. Secretary, please read.
Senate Bill 43 by Senator Lieu, an act relating to public social services.
Thank you, Mr. President. SB 43 will help CalFresh recipients retain their eligibility for federal food benefits in tough economic times and increase meaningful opportunities in the CalFresh Employment and Training Program. Specifically, the bill establishes self-initiated workforce option in counties that have a CalFresh Employment and Training Program. People can meet workforce requirements by volunteering at schools, food banks, fire departments, and other nonprofits. It also helps better track and see what's working in these programs and it aligns work rules for CalFresh E&T participants to federal work rules so that when the federal government waives work rules for the county due to high unemployment, CalFresh participants don't get unfairly penalized. This bill has broad support from business and anti-hunger and consumer advocates and enjoys unanimous support in all communities, and I respectfully ask for your aye vote.
Members, is there debate or discussion? Debate or discussion? Any objection to substituting the unanimous roll call? Seeing and hearing none, ayes 38, noes 0. The bill is passed. File item 44, Senator Corbett. Mr. Secretary, please read.
Senate Bill 44 by Senator Corbett, an act relating to public utilities.
Thank you very much, Mr. President and members. Senate Bill 44 requires that natural gas operators improve communication and coordination with first responders by requiring the California Public Utilities Commission, in consultation with the California Emergency Management Agency and the California Fire Chiefs Association, to adopt stricter emergency response standards. In my district, which includes Fremont, San Jose, and Milpitas, there are natural gas transmission lines that are of concern because...
Members, one moment, please.
Thank you very much. These transmission lines are of concern because of their proximity to the Hayward Fault Line and because they've been listed as many of the most dangerous lines in the Bay Area. And members, I'm sure you have these types of concerns in your districts as well, and if you've shown that through your support as this bill has moved through the process. According to the U.S. Geological Survey, a chance of having a one or more magnitude 6.7 or larger earthquake in the California area over the next 30 years is greater than 99%. And the most likely fault in Northern California to have such a quake is the Hayward Fault. Knowing this information, we should make sure that we are prepared not only along the Hayward Fault, but throughout the state of California. I've had the opportunity to meet with PG&E and other utilities and my local fire chiefs multiple times, and as a result of these meetings, this bill has been authored. And I believe that this bill will address gaps and federally required emergency response plans. The bill has the support of fire chiefs, the firefighters, utilities, and consumer groups, and I want to especially say thank you to PG&E for their support and their cooperation on this particular measure. I ask for your aye vote.
Debate or discussion? Debate or discussion? Seeing and hearing none. Members, is there any objection to substituting our unanimous roll call on this item? Seeing and hearing none, ayes 38, noes 0. The bill is passed. File item 45, Senator Runner. Secretary, please read.
Senate Bill 57 by Senator Runner, an act relating to sex offenders.
Thank you, Mr. President and members. SB 57 is based substantially on New York State's e-stop law. It will require all registered sex offenders to disclose their online social network addresses as part of their annual registration requirement. Illinois has also adopted a similar law. The bill is a narrow version of SB 1204, which passed out of this House last year. As most of you know, John Albert Gardner confessed last year to the rape and murders of both Chelsea King and Amber Dubois in San Diego. He had a MySpace page with graphic descriptions of sex acts. The last time he accessed this website was the day before he killed Chelsea. SB 57 simply adds a data field to the sex offender registration form, which already requires sex offenders to annually register their residence, workplace, and vehicle information. As we observed on the floor just last week, although online networking is a huge social phenomenon with many positive effects, it also has a darker side, and we need to find the balance between them in order to keep our children safe from predators. SB 57 does not deny anyone access to social networking sites. It does, however, give sex offenders reason to think before engaging in predatory practices on the internet. SB 57 is a bipartisan bill, currently co-authored by Senators Anderson, Calderon, Harman, and Liu, and I will be adding Senator Elaine Alquist as the principal co-author as soon as possible. I'd ask for your aye vote.
Debate or discussion? Senator Leno.
Thank you, Mr. President. Just question of the author.
Yes.
I'm reading in the analysis that the fiscal analysis that the bill has potentially significant state reimbursable local enforcement costs from the general fund. I wondered how you figured we would pay for this.
Well, of all the witnesses and the law enforcement that we talked to, don't believe there's any cost to just add simply another line to the requirement for the sex offender. They're already doing their addresses, where they live, so it's basically just one more line to add to the form that they already have. So they don't believe there's any cost to be reimbursed.
So though that was the determination of the
Yes.
Appropriations Committee. Okay, thank you.
Thank you.
Further debate or discussion? Seeing and hearing none, Senator Runner, you may close.
I'd ask for an aye vote. Thank you.
Secretary, call the roll.
Alquist. Aye. Anderson. Aye. Berryhill. Aye. Blakesley. Aye. Calderon. Aye. Canella. Aye. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Dutton. Aye. Emerson. Evans. Fuller. Aye. Gaines. Aye. Hancock. Aye. Harmon. Aye. Hernandez. Aye. Huff. Aye. Kehoe. Aye. LaMalfa. Aye. Kehoe, I don't know. Leno. Ted Lieu. Aye. Carol Lieu. Lowenthal. Aye. Negrete McLeod. Padilla. Aye. Pavley. Price. Aye. Rubio. Aye. Runner. Aye. Semidian. Aye. Steinberg. Strickland. Aye. Vargas. Aye. Walters. Aye. Wolk. Aye. Wright. Aye. Wyland. Aye. Yee. Yee. Aye. Correa. DeSaulnier. Aye. Emerson. Evans. Leno. No. Carol Lieu. Negrete McLeod. Pavley. Steinberg. Pavley, aye. Steinberg.
Ayes 32, noes 2. The bill is passed. File item 46, Senator Price. Secretary, please read.
Senate Bill 67 by Senator Price, an act relating to public contracts.
Thank you, Mr. President. Members, Senate Bill 67 authorizes the Department of General Services to direct state departments and agencies to achieve a goal of 25% small business participation in procurement and contracts and empowers DGS to assist agencies to meet the goal. The bill codifies the former Governor Schwarzenegger's executive order and ensures that some of the ground small businesses have gained in state procurement and contracting within the past few years will continue in the future, regardless of party. Since the issue is already in effect, the costs to administer the provisions of the bill are minor and absorbable, as indicated in the analysis of the Senate Appropriations Committee. Over the last 2 fiscal years, state agencies have met or exceeded the 25% goal. Codifying the executive order will contribute to the continued success of California small businesses in state procurement and contracting and support their roles as key drivers of job growth and economic development in the state's recovery efforts. Small business is expected to play a critical role in our state's recovery effort. However, very little support has been provided to assist them. Senate Bill 67 provides support to achieve this goal and has support from a wide cross-section of business organizations. I urge you, I vote on this important measure to help ensure success of California's small businesses.
Debate or discussion? Debate or discussion? Seeing and hearing none, Secretary, call the roll.
Alquist. Aye. Anderson. No. Berryhill. Aye. Blakesley. No. Calderon. Aye. Canella. Aye. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Aye. Dutton. Emerson. Evans. Aye. Fuller. Aye. Gaines. Aye. Hancock. Aye. Harmon. Aye. Hernandez. Huff. Aye. Kehoe. Aye. Hernandez. Aye. LaMalfa. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. I, Rubio. Runner. I, Smidian.
Aye.
I, Steinberg. Strickland. I, Vargas. I, Walters. No, Wolk. I, Wright. I, Wyland. I, Yee. Yee, aye.
Ayes 31, noes 4. The bill is passed. File item 47, Senator Price. Secretary, please read.
Senate Bill 100 by Senator Price, enacting the Healing Arts.
Members, Senate Bill 100 strengthens the regulation and oversight of fertility clinics and surgical clinics performing cosmetic procedures and ensures that the quality of care standards are in place at these clinics and checked by the appropriate accrediting agency. The bill will provide protection to patients by specifying the level of inspections of these clinics, requiring accrediting agencies to make an immediate determination as to whether a problem clinic should continue to operate with a corrective plan or to suspend or revoke its accreditation, and to prevent that clinic from getting accreditation elsewhere if the approval is revoked. Also, the bill would require the medical board to establish an appropriate level of physician availability in medical spa-type clinics, which is growing in popularity amongst consumers. Senate Bill 100 has no opposition and is supported by physician groups, including the California Medical Associations. I ask for your aye vote.
Debate or discussion? Debate or discussion? Seeing and hearing none. Members, any objection to substituting our unanimous roll call? Any objection? Ayes 38, no. Ayes 37, no 0. The bill is passed. File item 48, Senator Lowenthal. Mr. Secretary, please read.
Senate Bill 119 by Senator Lowenthal, enacting community care facilities.
Thank you, Mr. President.
One moment, please.
I rest my case.
One moment, please. Senator Lowenthal, please proceed.
Well, thank you. I appreciate that. Mr. President, SB 119 creates a licensing category for emergency youth shelter facilities. It defines and describes an emergency youth shelter facility and directs the Department of Social Services to adopt regulations by January 1, 2013. This bill would ensure that emergency youth shelter facilities continue to be eligible for federal funds. This bill has had bipartisan support and has had no votes. This is a reasonable approach that allows us to apply for federal funds. I ask for your aye vote.
Debate or discussion? Debate or discussion? Seeing and hearing none. Members, any objection to substituting the unanimous roll call? Seeing and hearing none. Ayes 37, no 0. The bill is passed. File item 49, Senator Carol Liu. Mr. Secretary, please read.
Senate Bill 121 by Senator Liu, enacting the pupils.
Thank you, Mr. President. SB 121 addresses issues relating to the placement of foster youth in non-public schools. Current law requires foster youth to attend public schools unless the pupil's IEP or the individual education plan or parent education rights holder calls for another placement. Despite this, some foster youth are being placed in an NPS, that's a non-public school, before the determination is made by either the education rights holder or the IEP plan. This bill prohibits the referral to or placement in a non-public school unless the foster youth plan specifies such placement is appropriate or the education rights holder places the pupil in a non-public school. The bill also clarifies that referral or placement by the school district is pursuant to the IEP team decision. SB 121 ensures that the actual holder of educational rights makes the decision to place the pupil in the NPS or non-public schools, and I ask for your support on the bill.
Debate or discussion? Debate or discussion? Seeing, hearing none. Secretary, call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Aye. Canella. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Herman. No. Hernandez. Aye. Huff. No. Kehoe. Aye. LaMalfa. No, Leno. I, Ted Lieu. I, Carol Lieu. I, Lowenthal. I, Negrete McLeod. I, Padilla. I, Pavley. I, Price. I, Rubio. I, Runner. No, Smidian.
Aye.
I, Steinberg. Strickland. No, Vargas. I, Walters. No, Wolk. I, Wright. I, Wyland. Yee. Yee, aye. Huff. No to aye. Cannella, aye.
Ayes 25, noes 11. The bill.
Wyland, no.
Ayes 25, noes 12. The bill is passed. File item 50. Senator De Leon. Are you prepared to take this item up, sir? Then, Secretary, please read.
Senate Bill 124 by Senator De Leon, enacting to ammunition.
Thank you, Mr. President. Members, SB 124 is the Cop Killer Ban Protection Act, which I introduced in response to a recent court ruling that called into question the definition of handgun ammunition and cop killer bullets. SB 124 simply clarifies the definition of cop killer bullets to include the bullets that are designed to penetrate body armor when fired from a handgun. This clarification is designed to preempt future litigation on this matter and to keep cop killer bullets illegal in the state of California. Before I conclude, I would like to quote testimony from Los Angeles Police Department Sergeant John Muma, who stated in the Public Safety Committee here in the Senate, quote, "There is no reason for the public to purchase these type of bullets. They serve no other purpose. They are not for sport. They are not for hunting. They are for killing people, specifically police officers. Directly across the street from this great building on the grounds, there's a memorial. If this bill passes and keeps at least one name from that memorial of fallen officers, then you've done your job. The motto of the Police Protective League is to protect those who protect others. This is our opportunity to request that we will work together to protect police officers across the state of California. This is a measure that is strongly supported by law enforcement across the state of California. Members, I respectfully ask for an aye vote.
Discussion, members. Senator LaMalfa.
Thank you, Madam President. I rise in strong opposition to this bill. The only reason we're doing this bill here today is because pieces of AB 962 were found to be unconstitutional and very vague. This does not bring any more protection for the so-called cop killer bullets. The statutes are already in place to keep those from the hands of those that would be using them against our officers. Passage of 124 is not required to preserve the regulation that is already in place. This is merely a measure to move towards less ammunition being available to all people that are law-abiding gun owners, and to include types of ammunition that really have nothing to do with handguns at all. Perhaps if a handgun has ever been made as a model or a prototype that may use a long rifle or even a shotgun shell, but is not a mainstream type of handgun, this bill is trying to include that type of ammunition. So any type of piece of ammunition that could have ever been rendered as possibly used in a handgun, even though the handgun is not one that's, again, regular production or regularly made, this tries to ensnare that so that the end effect is that all ammunition will be regulated in this fashion. It goes in the wrong way towards the spirit of the Second Amendment, or even what previous legislation has attempted to do. It certainly is not about cop killer bullets because, again, those are very well regulated as is. So I ask for your no vote.
Additional discussion, Senator Harman.
Thank you very much, Madam President. I'm sure we may disagree on this bill, but we do agree with the goal of it, and that is to keep law enforcement safe. I'm a lifelong sportsman and hunter, and I know it's nearly impossible to define handgun ammunition. The language in this bill defines handgun ammunition as being capable of being used in pistols, revolvers, etc. The problem is that a great deal of ammunition that is used in handguns is also used in long guns. The legislature has previously attempted to define what constitutes handgun ammunition, and the definition was found unconstitutional, as referenced by Senator LaMalfa. That's the case of Parker versus California. While I want to keep law enforcement safe, this bill is not a solution to so-called cop killer ammunition, which many people say really doesn't exist anyway. It merely penalizes law-abiding sportsmen without protecting, I should say, law enforcement. I urge a no vote. Thank you.
Senator Gaines.
Yeah, I rise in opposition. I've got real concern in terms of the language with regards to armor-piercing ammunition and the use of the word primarily as opposed to principally. And I want to make sure that we're very clear on what we're including in the definition of armor-piercing. I think there is a broad crossover that can create real problems for a lot of my constituents in my district who are hunters that are using high caliber guns. And again, this is a continued reduction of Second Amendment rights. And we're seeing this continually happening here in the state. And I'm very fearful that this, along with what looks to be projected reduction in our prison population, is going to create havoc across the state of California. Here we are limiting, again, the options to gun owners, while at the same time we're declaring that our prisons are overcrowded. And I think that was an incorrect decision by the Supreme Court. We've got real challenges in front of us in terms of keeping our citizens safe. So I urge a no vote.
Additional discussion, members? Any additional discussion? Seeing none, Senator De Leon, you may close.
Thank you, Madam President. Let me make a few clarifications. I do appreciate my colleagues' opinions on this issue. With regards to the Second Amendment of the Constitution of the United States, this is not germane to that issue because we're dealing with handgun ammunition specifically, not the right to bear arms. So I want to make that correction. Secondly, with the issue with regards to quote-unquote cop killer bullets, definitions of cop killer bullet is ammunition that has the ability to pierce a Teflon armor, which is commonly known as a bulletproof vest. And when I emphasize, and let me underscore, highlight, bold, and as well as italicize the strong support from law enforcement, those groups and individuals who are behind this bill, SB 124, are in fact law enforcement officers. Madam President, if you don't mind, I'd just like to go quickly of the strong support from law enforcement. We have the Alameda Police Department, the Arcadia Police Department, the Association for Los Angeles Deputy Sheriffs, commonly known as ALADS, the Chico Police Department, the cities of Beverly Hills, Hillsburg, and Los Angeles, Imperial Police Department, Inglewood Police Department, the Los Angeles County Sheriff's Department, Los Angeles Police Department, Los Angeles Police Protective League, Modesto Police Department, Oakland Police Department, Oxnard Police Department, the Peace Officers Research Association of California, known as PORAC, the California Highway Patrol Association, the Riverside Sheriff's Association. Let me emphasize that again. The Riverside Sheriff's Association, the Sacramento Police Department, the San Bernardino Police Department, the Santa Ana Police Department, the South Pasadena, Stockton Police Department, as well as the Vallejo Police Department. I think that's a clear reflection of the police departments across the state of California, whether they be in urban centers, whether it be rural or suburban. Again, this protects the law officers, the men and women who put their lives on the line every day to protect us, the community. So therefore, colleagues, I would respectfully ask for an aye vote on this measure to make sure we ban cop killer bullets from being either A, manufactured, possessed, or used in the state of California. I respectfully ask for an aye vote.
Secretary will call the roll.
Alquist? Aye. Anderson? No. Berryhill? No. Blakesley? No. Calderon? Aye. Canella? No. Corbett? Aye. Correa? No. De Leon. Aye. DeSaulnier. Aye. Dutton. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe.
Aye.
Aye. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Runner. No. Smidian. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. No. Wolk. Aye. Wright. No. Wyland. No. Yee. Yee, aye. Dutton, no. Smitty and aye.
Secretary will call the absent members.
Emerson. Rubio.
That completes the roll. The ayes are 22, the noes are 16. The measure passes. We are on file item 51. Senator Lowenthal, are you prepared? The Secretary will read.
Senate Bill 128 by Senator Lowenthal, enacting relating to school facilities and making an appropriation therefore.
Senator Lowenthal. Members, can Senator Lowenthal have your attention? Thank you.
Madam President, members, Senate Bill 128 does two things. It allows career technical education construction projects to be eligible for funding under the High Performance Schools program, and it allows modernization projects to include new green building systems. The State School Facility Modernization Program provides funding to renovate school facilities that are at least 25 years old. Current law does not allow new green building systems to be funded under the modernization program. While new school facilities must meet certain environmental standards, our older classrooms remain ineligible for funding for some of the new green building systems, creating inequities in our K-12 learning environments. Green school facilities can affect the academic performance of our pupils. Daylighting, clean, well-circulated air, and good acoustics can all contribute to better pupil performance. We all know that school districts can save operational dollars through the addition of energy efficiency and energy generation projects. This SB 128 does not add cost to the state. The bill simply allows local flexibility for the use of existing state funding. It provides teachers and children housed in our older schools and in career technical education classrooms to have the opportunity to have the same healthy learning environments that are enjoyed in our new schools. I ask for your aye vote.
Discussion, members? Senator Wyland. Thank you.
Madam President, members, I rise in support of this bill. We see a lot of so-called green legislation which mandates the use of so-called green buildings and doesn't allow the individual jurisdiction to make that choice because, generally speaking, these facilities do cost more. But the advantage of this bill is it simply allows the entity to do it. It allows the entity access to those funds, which currently isn't a possibility, and includes CTE money. We've talked a lot about CTE money here. The reality is that so-called career technical education or vocational education is one of the primary reasons that many students drop out of school. And if there is a jurisdiction which wants to use this type of building, and they want to use it to access those CTE funds or those facilities, I think we ought to let that jurisdiction make the decision. I urge your aye vote.
Any further discussion, members? Is there any objection to using a unanimous roll call on this item? Any objection? Objection. We'll call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. I. Calderon. I. Canella. No. Corbett. I. Correa. De Leon. I. DeSaulnier. I. Dutton. No. Emerson. Evans. I. Fuller. No. Gaines. No. Hancock. I. Harmon. No. Hernandez. I. Huff. No. Kehoe. I. LaMalfa. No. Leno. I. Ted Lieu. I. Carol Lieu. I. Lowenthal. I. Negrete McLeod. I. Padilla. I. Pavley. I. Price. I. Rubio. I. Runner. No. Semidian. I. Steinberg. I. Strickland. No. Vargas. I. Walters. No. Wolk. I. Wright. I. Wyland. I. Yee. Yee, I. Correa, I.
Ayes 27, noes 12. The measure passes. Senator Lowenthal, you have the next item. You taking that up? The Secretary will read.
Senate Bill 140 by Senator Lowenthal, an act relating to pupil instruction.
Senator Lowenthal.
Thank you, Madam President. Members, the State Board of Education adopted the Common Core standards in English language arts and mathematics in August of 2010. Simply speaking, what we did is we joined with over 40 other states to try to come together to try to develop national standards, academic standards in English language arts and mathematics. The problem or the issue is our process of reviewing and updating curriculum frameworks and adopting instructional materials is suspended until 2015 and 16. That we've done primarily as a budgetary thing, so we're not adopting new materials at least until 2015 and 16. The problem is that we need a bridge in terms of instructional materials that because we potentially will be going to this national assessments in 2014. So California students are going to be assessed on Common Core standards in 2014, potentially. That's when they're supposed to come out, the new assessments. But our new materials will not come into, will not be developed until 2015 and 16, until the earliest. So without penalizing California students, we need this bridge, instructional materials, to align our existing standards with these Common Core standards. And that's exactly what this bill does. It allows us to develop those materials so California students will not be penalized by being assessed by national assessments and yet not have the instructional materials in front of them. I ask for your aye vote.
Is there discussion, members? Any discussion? Senator Wyland.
Question of the author.
Senator Lowenthal, will you take a question from Senator Wyland?
Certainly.
This allows the adoption of those materials. Who actually is going to create those materials? Will that be done through the regular process? What's the source?
Well, the process will be very interesting. The process, what we'll do is right now that this will allow school districts, if they wish, even K through 8, to engage in the same process by which they can adopt materials as long as they go through a process of a public resolution and have a public hearing of that, as long as they can document that every student has been provided with a standard-aligned instructional materials. They will also be held accountable in terms of school districts, in terms of how their students do on their test scores, their standardized tests that will come up. In addition, what will happen also in the development of it is that the California Department of Education will develop this bridge, these instructional material, and submit that to the State Board of Education. Once the State Board of Education approves this kind of bridge instructional material, the textbook publishers will then working from this, will then prepare that material. School districts will have the option of either developing their own and going through this public process with their own, or adopting the materials that the State Board of Education and the Department of Education have adopted. They will still go through the same kind of process, the same reviews, whether it's at the local level or at the state, and that will now enable us at least to get through this gap period where our students are going to be assessed on the Common Core standards, and yet we will not have the instructional materials for them.
And the Common Core standards, so everyone understands, that have been adopted, will be adopted by the state, are mathematics and English. Those are the two subject areas.
Those are the two.
I rise in support of this bill. I wouldn't necessarily normally, because the process by which the adoption is different from what we've done. But the reality is we've adopted these standards. They're in English, language arts, and math. And we interrupted wrongly, through a budget process, mistakenly, the funding for the adoption of curriculum.
That's right.
We interrupted it in social studies when it had almost been done. We've interrupted it in science. This, frankly, members, is something a little esoteric. A lot don't understand. It's crucial to the future of this state. We have a dropout rate among young African Americans and Latino students, which is about 50% in LAUSD, and probably that high. So one of the things we haven't done, and it's shameful, is develop better curriculum for English language learners. It's one of the reasons they drop out. They get to 8th grade, 9th grade, and they can't read. So I think we have to do whatever possible to get that curriculum material in front of those kids. We're all going to be better off in California if we can keep them in school. They need to learn how to read, and we need to do a better job for it. So I support the bill.
Anything further, members? Anything further? Then the Secretary will call the roll.
Alquist? Aye. Anderson? No. Berryhill? No. Blakesley? No. Calderon? Aye. Cannella? No. Corbett? Aye. Correa? De Leon? Aye. DeSaulnier? Aye. Dutton? No. Emerson? Evans? Aye. Fuller? No. Gaines? Hancock? Aye. Harmon? No. Hernandez? Aye. Huff? No. Kehoe?
Aye.
Aye. LaMalfa? No. Leno? Aye. Ted Lieu? Aye. Carol Lieu? Aye. Lowenthal?
Aye.
Aye. Negrete McLeod? Aye. Padilla? Aye. Pavley? Aye. Price? Aye. Rubio? Aye. Runner? No. Smidian? Aye. Steinberg? Aye. Strickland? Vargas? Aye. Walters? No. Wolk? Aye. Wright? Aye. Weiland? Aye. Yee? Yee, aye. Correa, aye. Gaines, no.
Ayes 26, noes 12. The measure passes. We are at file item 53, Senator Rubio. Senator Rubio not at his desk. File item 54, Senator Evans. The clerk, the Secretary will read.
Senate Bill 155 by Senator Evans, enacting to health care coverage.
Senator Evans.
Thank you, Madam President. And members, this bill is one of a package of bills that I've been carrying this year, designed to ensure that we protect women who are pregnant and need to take maternity leave. This bill will ensure that women have access to health insurance policies that include maternity coverage. Women are more and more often having to buy their own health insurance in the individual market, and they're facing an increasingly difficult time finding policies that include maternity care. In 2004, 82% of these types of policies included maternity coverage. Today, however, only 12% of these policies include maternity coverage. And if the trend continues, women will be left unable to find policies on the individual market that include maternity coverage. It's discriminatory, it's unfair, and it leaves women and their babies unprotected. This measure left committee with bipartisan support, and I ask for your aye vote.
Any discussion, members? Any discussion? Seeing none, the Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. Aye. Calderon. Aye. Canella. Corbett. Aye. Correa. De Leon. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe.
Aye.
Aye. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Smidian. Aye. Steinberg. Aye. Strickland. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. No. Yee. Yee. Aye.
Call the absent members.
Canella. Correa. Aye. De Leon. Aye. Emerson. Strickland.
Ayes 26, noes 11. The measure passes. Next is file item 55, Senator Simidian, and then we'll return for Senator Simidian to file item 41 and 42, which he passed when he was presiding. So we're at file item 55, members, and the Secretary will read.
Senate Bill 164 by Senator Simidian, an act relating to taxation.
Senator Simidian.
Thank you, Madam President. Members, this is a simple sunset extension for the tax checkoff for the prevention of child abuse and the tax checkoff for rare and endangered species preservation program. These two programs are set to expire. The bill would simply extend the sunset date to January 1st, 2018. Members, this is a voluntary checkoff for members of the public who have chosen to give more than $1 million a year to the state of California. Always a good thing, but if ever there was a time it's a particularly good thing, it's right now. I would respectfully ask for an aye vote.
Any discussion, members? Any discussion? Seeing none, the Secretary will call the roll.
Alquist. Anderson. Berryhill. No. Blakesley. Aye. Calderon. Aye. Canella. Aye. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. Emerson. Evans. Fuller. No. Gaines. No. Hancock. Aye. Harmon. Aye. Hernandez. Aye. Huff. Kehoe.
Aye.
Aye. LaMalfa. Aye. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. Smidian. Aye. Steinberg. Aye. Strickland. Aye. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. Aye. Yee. Yee. Aye.
Call the absent members, please.
Anderson. No. Alquist. Aye. Dutton. Emerson. Evans. Aye. Huff. Gaines. No to aye. Runner. Runner. Aye.
Ayes 33, noes 4. The measure passes. We'll return to file item 41. File item 41, members, and the Secretary will read.
Senate Bill 27 by Senator Simidian, an act relating to public retirement systems.
Senator Simidian.
Thank you, Madam President. Members, this is the pension anti-spiking bill. It is substantially similar to last year's measure, which Governor Schwarzenegger indicated he had been prepared to sign but could not because it was attached to an assembly member that he did not think he could sign at the time. So we've reintroduced the measure. Last year, the measure went through both houses unanimously in every committee and on the floor of both houses. This year, there were no votes in either the Policy Committee or the Appropriations Committee. bill is designed to do two things for our CalPERS and CalSTRS programs: to prevent pension spiking, the process of loading up final year or years of compensation to artificially inflate a pension, and also to prevent what is sometimes referred to as revolving door double dipping, where folks, quote, retire on Friday but then show up at work again on Monday, pulling down two salaries, and in some cases even involving a third salary if they're there to provide mentorship to a subsequent person. I would respectfully ask for an aye vote.
Any discussion, members? Is there discussion? Senator Gaines.
Yes, I just wanted to rise in support. Wanted to thank Senator Simitian for bringing this forward. It's one step forward in terms of pension reform. We've got much more to do, but appreciate what he's brought forward. Thank you.
Members, is there any objection to a unanimous roll call? Is there an objection? Then we will add Senator Steinberg, and the vote is 39-0. The measure is out. Next is item 42, and the Secretary will read.
Senate Bill 36 by Senator Simitian, an act relating to health care coverage.
Senator Simitian.
Thank you, Madam President. Members, this measure would simply authorize, and I want to underscore authorize, does not require, there is no mandate. It would allow counties that have chosen to participate in the County Health Initiative Matching Fund Program to receive additional federal funding. Recent changes in federal funding have allowed now for families that are between 300 and 400% of the poverty level to receive additional federal support. This simply authorizes counties to participate and access if they choose to do so. While 300 to 400% of poverty level may sound like a fairly significant income, California, as we know, is often disadvantaged in federal calculations because of our high cost of living, and that is particularly the case in selected high-cost counties here in California. If we don't vote aye, that means we leave kids uninsured unnecessarily, and it also means that we leave federal money on the table that will simply go to some other state if we fail to use it. Respectfully ask for an aye vote.
Senator Blakesley.
Thank you, Madam President. I sadly must rise in opposition. I don't believe there's any such thing as free federal money. Last time I checked, those monies do come out of the pocketbooks of hardworking Californians. And to raise the ability to take advantage of some of these subsidies up to 400% of the federal poverty level